Welcome to the fourth in a 5-webinar series on buy-sells. This webinar is about owners agreements, which include shareholder agreements, operating agreements, and partnership agreements. My name is Erin K. I'm a partner with Duffy LLP. I've been representing businesses and primarily auto dealerships and buy-sells for over 30 years. The first webinar in this 5-webinar series was about the 3 different types of buy-sell agreements. Part 2 was the basics of asset purchase and sale agreements. Part 3 was the basics of stock purchase agreements. If you want to view those webinars, you can find them at our website, www.grayduffylaw.com, under News. This webinar, as I said, is on owners agreements. The final webinar in this series will be on real property purchase agreements and how real estate fits into each of the 3 different types of buy-sell transactions. In the future, look for my webinar on financial considerations in buy-sell agreements. Today we're going to cover the different types of owners agreements, some of the important provisions that are in all of them, and their differences. When an ownership interest is transferred, in addition to the agreement that will affect the transfer, which is what we talked about in the last webinar, a separate agreement is needed to govern the relationship between or among the owners after the transfer. The name of that agreement will depend on the type of entity in which ownership interests are held. If it's a partnership, it'll be a partnership agreement. If it's a LLC, it'll be an operating agreement. And if it's a corporation, it'll be a shareholders agreement. All of these agreements have similarities and differences. The similarities are that they all answer 7 important questions. First, what happens on death of a shareholder? Does the shareholder get to leave their interest to their heirs, or do they have an obligation to sell it? Do the other owners have a right to buy it? What happens on disability of a shareholder or owner? When I say shareholder, I'm kind of using the word interchangeably, since most of the agreements I deal with happen to be shareholder agreements or operating agreements, but shareholder is a more common term. So just know that when I use that term, I'm talking about shareholders, members, or partners. So on disability, does the disabled shareholder have a right to keep their shares, or do they have an obligation to sell it? What happens upon divorce? Does a divorcing spouse who is awarded an interest in divorce get to keep that interest, or do the other owners have a right to buy out the spouse? What happens upon loss to creditors? If a shareholder gets into financial trouble, or an owner gets into financial trouble and loses their interest to a creditor, do the other owners have a right to buy them out? And what happens on retirement, or if an owner just wants out? Do the other owners have a right to buy them out? Can they just leave and keep their interest? And then with respect to all of these different issues, what price? If there is a right or obligation to sell, what will the price be, and what will the terms of sale be? With no agreement in place, an owner who dies will leave their interest to heirs, which may be a spouse or children or somebody else who may want to get involved in the business or not think that the other owners are acting in their best interest. And this can cause problems because if they're a minority owner, they have dissenters' rights. If they're a majority owner, they're going to have some controlling rights. A dissenting shareholder can result in conflicts that can lead to dissolution of the business, because what usually happens is they end up, if they can't resolve their disputes, they end up filing a derivative action on behalf of the corporation for mismanagement, and that typically involves or results in appointment of a receiver if there was mismanagement, and then the receiver proceeds to liquidate the business. So you don't want to find yourself in that position, because liquidation value is the lowest value you will ever get for your business. So how these interests are treated will vary slightly depending on the type of agreement. However, typically an owner's agreement will give the company or the other owners either the right to buy out the deceased owner at a price and on terms set by the agreement, or will require them or the company to buy out the deceased owner's interests. When the company buys the interest, it increases every other owner's interest proportionately. And typically, if it's the other owners that have the right to buy the interest, they also have proportional rights. Just a little more complicated in the way it's drafted. Life insurance can be purchased for a buyout on death of a shareholder, and it typically is provided for in an owner's agreement. The policy can either be purchased by the entity or by the individuals. If it's purchased by the entity and the entity deducts the premiums, then the proceeds will be taxable. If it does not deduct the premiums, then they will be attributable to the individual owners as income and taxed as income, and then the proceeds will not be taxable. In the event of disability, there's usually a definition in the owner's agreement of what is permanent disability, and it typically means that the person cannot be reasonably accommodated in retaining their position if they work in the business, or is going to be out for such a long time that it's not reasonable to hold open the position. If they do not work in the business, it usually has to do with the length of the disability and the ability of the person to manage their own affairs. So what typically happens upon permanent disability is one of two things. Either the disabled owner is allowed to retain their interest, or they're required to sell. If the disabled owner is an employee, which is usually it's a general manager, the other owners will likely want to replace them with a new general manager, because often the manufacturer's agreement will require that a general manager own an interest in a dealership. Not all of them do, but some do. And so you want to make sure that you get that interest back, have the right to buy it back, so that you can sell it again to a different owner, to a different general manager that you hire. If the disabled owner is not active in the business, then retaining the interest may be the preferred solution. Even so, other owners might want an option to buy that interest, or a disabled owner might want the option to sell because they might need the cash. Whenever an option is given to an owner to buy more of the company, there are tax consequences that need to be considered. I'm not going to go into all of those today because they can get very complicated, but generally speaking, if an option is going to be given to an employee owner to buy an interest in the business and it's not going to be exercised within 3 months of when it vests, the transaction could be construed to be deferred compensation under Internal Revenue Code 409A, which is a very complicated and lengthy code section with a lot of twists and turns, and it requires careful consideration and planning to make sure that you fall into one of the safe harbor provisions of that code section. If you don't do that, you can end up paying so much in taxes that it literally wipes out the value of the option. With no owner's agreement, a disabled owner will have the right to retain their interest, no right to cash it out, and there will be little any other owner will be able to do to get the disabled owner to sell unless they want to. And little the disabled owner will be able to do to get the company or other owners to buy them out unless they want to. So what happens on divorce? If a owner loses their interest in a divorce, typically the owner's agreement will provide that that owner will have an option to buy the interest back. If they don't exercise the option, then the option goes to the other owners or to the company to buy that interest. The spouse must sign a spousal consent when the owner's agreement is signed for this provision to be enforceable. If the divorcing owner does not want to buy the interest, as I said, the company will typically be given an interest, and it can, if it buys it, everybody else's interest is increased proportionately, or the other owners typically have the right to buy in proportion to their respective ownership interests. With no agreement, the spouse will have the right to retain the interest and receive distributions when they're made. How the spouse will be treated is going to vary slightly depending on the type of entity, and I'll talk about those different types of entities in a little bit. But generally, the spouse will also have the right to be fully informed about all finances of the company and will have dissenters' rights, which means if they're not happy, they can cause trouble. So what rights does an owner have if a creditor attaches a claim? Again, it's going to vary depending on the type of entity, but generally speaking, if a creditor is assigned an owner's interest to satisfy a debt, the owner's agreement will typically provide that the other owners will have the option to buy out the creditor. The creditor could argue that because they were not a party to the agreement, it's not enforceable. However, most creditors would be happy to take the cash. A creditor who will become an owner will be very interested in cashing out their interest, and they are probably the most likely to force a dissolution if they cannot get paid. So you don't want to end up partners with a creditor of one of your former partners. If the interest is owned by an LLC, or if the interest is in an LLC, the creditor will only be able to get a charging order, which provides some benefits to the other owners because the creditor can't actually become an owner. All they can get is an interest in the distributions that the owner was entitled to receive. So it's one of the benefits of having an LLC over a corporation. In a corporation, the creditor would be able to actually attach the shares and foreclose on them and become an owner. So what happens if you've got an owner who wants to retire or is just unhappy and wants out? This is one of those issues that almost always comes up at some point in every business that's owned by more than one person. Either a partner wants to retire or a partner is just not satisfied and wants out. Having a written agreement on how it will be handled is important because it creates certainty so everyone can plan accordingly. The ability to plan can make what might have become a very stressful situation easy to manage, at least easier to manage. There are many ways to structure a dissatisfied or retiring owner provision. One possibility is to give the other owners an option or obligation to buy out a retiring or dissatisfied owner. Another option, if an owner is retiring, is to allow that owner to hold their interest or to remove themselves from the day-to-day operations. However, if that owner eventually wants to be cashed out and there isn't an agreement that entitles them to do that, it could be a problem later on. Still, another possibility is a typical dissatisfied parties clause, which goes by other names, sometimes Texas shootout provision, or I've seen other names as well. Typically, this provision just provides that the dissatisfied party has the right to set the price for the buyout in terms, and the other owners have the right to decide who's buying and who's selling. It's kind of a clever way to make sure that the price is set fairly. It doesn't always work out that way. Sometimes people don't do what they should do or what you would think they would do, and so it can lead to disputes. I haven't seen that happen a lot. Usually what happens when these provisions exist is the parties talk, they work something out, they negotiate a buyout, and if they can't agree, it becomes a fallback position. Having no agreement leaves all these possibilities on the table for discussion at the time an owner decides to leave or dies or becomes disabled or loses their interest, but leaves no one with any options unless everyone agrees on a solution at the time. So it's pretty risky. A much better solution is to negotiate an agreement with everyone while everyone is getting along and then reduce it to writing. So another provision that's typically in every owner's agreement is a provision that sets the purchase price. What price will be paid if an owner's interest is bought out, or how the price will be determined. The owner's agreement will always either state a formula price or provide for an appraisal. Formula prices are less common. A set price is pretty much unheard of because circumstances can change, so nobody wants to lock in a price. Values can go up or down drastically, as you saw in 2008. And, when I first started practicing law, the typical multiplier for goodwill was 2 to 3 times earnings. Now they vary from 2 to 10 times earnings. So things can change a lot over time, so you don't want to lock in a set price. A lot of people don't like appraisals because they feel like appraisers are can be bought and are sometimes not fair in their appraisals. In my experience, I haven't seen that happen. What I have seen, and it may be what people are noticing, is that appraisers have a certain amount of discretion in setting a purchase price. So there are certain things that are going to be fixed, but there are other things that they may or may not consider. For example, minority discount, lack of marketability discount. It may depend on the circumstances. So they have a certain amount of discretion when they're setting the price, and it can cause price swings of, I've seen as much as $2 million from an appraiser. So it is important to draft a provision that is as clear as possible, that guides the appraiser and what they can and cannot do. You can provide things like that there will be or will not be a minority discount for minority ownership interest, or there will or will not be a lack of marketability discount. These discounts can be up to 35%, so they can be significant. And there are other things that can be put into the agreement to guide the appraiser so there's more certainty. Another provision that's always included in an owner's agreement is how the purchase price will be paid. These are the terms of purchase. It will not include all the detailed terms of purchase. I'll talk about that a little more in a minute, but it will typically state that either the price can be paid all in cash at closing, or it can be paid by promissory note. Usually it's set at the discretion of the purchaser. If the purchaser can get the financing, they'll typically pay all cash. If they can't, then the seller will finance it, and it'll be via a promissory note, which will be attached to the purchase agreement as an exhibit, and a pledge of the interest, meaning that the seller gets it back if the buyer doesn't pay. And there'll usually be like a 10% down payment for that type of purchase. So as I mentioned, the promissory note will be an exhibit. There will also typically be an assignment separate from stock certificate, which is the document that will be signed to transfer an interest. The pledge agreement will typically also be an exhibit. Again, that entitles, didn't mean to do that. That entitles the owner to take back their interest, the seller to take back their interest if the buyer doesn't pay. And then you could attach a stock purchase agreement. People usually don't do that because they don't want to incur the expense of drafting a stock purchase agreement to attach. It's really not that expensive to draft a stock purchase agreement. Usually when the buyer is buying in, you're going to have one anyway. So because the factory typically requires a stock purchase agreement in order to approve a transfer, the manufacturer is always going to have to, or at least in most cases, is going to have to approve the transfer. In some cases, their dealer agreements will provide that a minority interest can be transferred without factory approval, but that's less typical. You can always just attach the stock purchase agreement that is used for the buy-in as an exhibit and say that that is going to be that it's going to be the same terms for the buyout if there is a buyout under the terms of the shareholders agreement. It's a really good idea because not having it leads to claims that an owner doesn't have the right to enforce the agreement at all. And I was recently hired as an expert in a case like that. I mean, it's not the kind of dispute you want to get into. I don't think that those claims hold up very well, unfortunately, because sometimes manufacturers will accept the shareholders agreement as the purchase agreement, so to speak, and will approve a buyer. The manufacturer could also decide that it's not going to do that and use the fact that there isn't a stock purchase agreement as leverage to not approve a buyer. Because they can always say, well, we need a purchase agreement, and if you can't agree on the terms of a purchase agreement, then there's no right to sell. So it's a good idea to have one attached. The stock purchase agreement is also going to include a lot of terms that are not going to be in the shareholders agreement, such as warranties and representations, conditions to the obligations of the parties, and indemnity agreements. So it is important to include a stock purchase agreement. So let's talk about the different kinds of agreements and some of the differences between them. So in an operating agreement, which is for an LLC, as I mentioned, the agreement will cover how distributions will be made, because unlike a shareholders agreement, the operating agreement for an LLC will allow for disproportionate distributions. It will also provide for allocation of profits and losses, which can be allocated disproportionately. And very significantly, it can provide that if somebody attains an interest, it can be only an economic interest with no voting rights, as opposed to a full membership interest, unless all the other members agree that the person should be a member. And in an operating agreement, there's typically a managing member that is named in the operating agreement. So those are some significant differences from a shareholders agreement. In a shareholders agreement, the managing parties are going to be the directors. And you're going to want to name the directors in the shareholders agreement. The directors elect the officers. They also decide whether anything out of the ordinary course of business can be done. And we'll talk a little bit more about that in a minute. Distributions in a corporation always have to be proportionate. They cannot be disproportionate. If they are disproportionate, then it's like having different classes of stock. Now, if you have a C corporation, it's not as big a deal. If you have an S corporation, which is what most dealership entities or dealership corporations are, the disproportionate distributions will be treated as another class of stock that can cause the entity to lose its S election. And then it ends up getting hit with C corporation taxes, because an S corp isn't taxed at the corporate level, but a C corporation is. Those taxes can be quite significant. A shareholders agreement will also always have a right of first refusal, because a shareholder, by one of its basic tenets, has to have free transferability of interest. That's not true for a limited liability company or a partnership agreement. So you can't just say that the owners have no right to transfer their interest to a third party. So the way you protect that interest from being transferred to a third party is you give the other owners a right of first refusal to buy the interest if an owner enters into an agreement to sell with somebody else. And that's always in a shareholders agreement. It can also be in a partnership agreement or an operating agreement, but it has to be in a shareholders agreement if you want to restrict the right to transfer. Also, in a shareholders agreement, you're going to provide for a legend to be placed on the share certificates. That is a statement that says that transfer of the shares is subject to the shareholders agreement. If you don't do that, it can have really significant consequences. An owner can transfer an interest, notwithstanding the fact that somebody else has an option to buy them or a right of first refusal, and the buyer will take that interest without being subject to those options or rights of first refusal. You won't be able to get the interest back. Whereas if there's a legend on the stock certificate, then any buyer is deemed to have notice of the shareholders agreement and is deemed to be on notice that there may be some provisions that they're taking subject to, and they will take subject to those provisions. So that's really important. So partnership agreements are different still, because a partnership is not treated as a separate entity for tax purposes. In addition, the partnership could be a limited partnership or it could be a general partnership. The difference is that in a general partnership, all partners are treated the same with respect to assets and liabilities of the partnership. However, in a limited partnership, the limited partners are typically paid first before the general partners upon liquidation of the partnership. Likewise, the limited partners have a limited liability for obligations of the partnership, unlike general partnerships. And they generally have limited participation as well. It's a way to provide some limited liability to investors, because a general partnership is not a limited liability entity like a corporation or a limited liability company. So A limited partnership is to the extent, or at least with respect to limited partners, not with respect to general partners. So if you have an owner's agreement, what could possibly go wrong? Well, unfortunately, there are still things that can go wrong. If you saw the movie about Facebook, you'll recall that the Winklevoss brothers had a shareholders agreement that provided that their interests could be diluted. That was mentioned in the movie, but the movie still made it look like the Winklevoss brothers were somehow cheated. They were not cheated, because what it means when there is a agreement that the interest can be diluted is that they agreed that their interest could be reduced. Here's how dilution works. Say, for example, there is one shareholder who owns 100% of the shares. He owns 100 shares. And the corporation issues another 100 shares. Now there are 200 shares, and the 100% owner is now a 50% owner. That's dilution. And the Winklevoss brothers did agree to that, so they were kind of out in the cold on that issue. Another consideration is allocation of the purchase price. A shareholders agreement usually will not, or an owner's agreement will usually not allocate purchase price. It can be important, though, to allocate purchase price, because if you're going to have a covenant not to compete, a lot of people think they're not enforceable in California. They are in certain circumstances, but only if goodwill is being transferred with the sale of an interest. So if you haven't allocated the purchase price so that it's clear that some of the purchase price is going to goodwill, then a covenant not to compete may be unenforceable. There is also an issue with, and all agreements should consider and include provisions governing the right of the owners to usurp a corporate opportunity. What that means is if an owner has other businesses that compete with or would have similar interests to the entity that the owner's agreement governs, they may have opportunities to either buy land or enter into leases or buy products that might be of interest to the entity that's the subject of the owner's agreement. If they take advantage of those opportunities without first offering them to the entity, there could be a claim made by a minority owner that they usurped a corporate opportunity. They should have offered it to the corporation first. If you want to have the right to do that, it needs to be stated in your owner's agreement that you have the right to do that. Otherwise, you expose yourself to those claims. If you want to preclude the right to do that, it should also be stated in the owner's agreement so there's less controversy over the issue and less likelihood of a lawsuit. Finally, there's the issue of self-dealing, which can be a very expensive issue for a minority owner who is not aware of what this means. So if you're a minority owner and you don't want to be in a position in which the majority owners have entered into contracts with the entity, with the corporation or the LLC, that diverts some of the profits of the company to them through that other business transaction, then you want a provision in your agreement that prohibits self-dealing. You could also, if you're an owner and you have those types of entities and you want to be able to enter into those types of self-dealing transactions, you can also provide in your owner's agreement that you have the right to do that. An example of this type of an agreement would be if an owner, say for example, sold the fixed assets of the entity to another business that he owns and then leased them back to the company. The company would pay rent, and it would be more expensive to the company than owning the assets. So that would be an instance of self-dealing, or charging above market rent on a lease. So these are the types of things you want to be aware of and include in an owner's agreement. I know some of the materials that went out said that this webinar was going to be an hour long. It is only a half hour long. I like to keep my webinars short because I know everybody's really busy. If you have questions, you can email me at eTenor@Gray Duffy Law or give me a call. My phone number's down in the bottom right there, Oh, that's my old number. My new number is 818-907-4071. So feel free to give me a call. Thank you for attending. Have a great day.